No fault litigation, it's a mad, mad world. It's high volume, it's fast paced, and it's technical. Not an easy subject area, and our adversaries are very well experienced and knowledgeable about the area. But the one thing that we have found to be critical in this area of insurance defense is perfection. You can't be just okay. Your documents, your paperwork, and our motions, and any kind of notices that get sent have to be perfect. A claim can be blown by an attorney if we're off by a digit on a zip code. Perfection is key. And it's a constant, never-ending area of law that is updating every day. Something new is happening, something different is happening, there's a new law being passed, there's new litigation that's being promoted, and being on top of that is also critical.
Eye for detail. I remember when I first started at the firm, the first thing I was told is 4 eyes have to see every document that goes out in the mail.
Who told you that?
I think you did.
Some wise man.
So in other words, once I drafted a document, I cannot just put it in an envelope and get it sent out. And someone else had to take a look at it. And most of the times, it was actually great. It was both a learning experience for me because there's edits, and usually always is. And and I wouldn't even have thought to have changed it. It made me a better practicing attorney.
Well, we're all human too, and oftentimes we have 3 sets of eyes on the document that goes out.
Simultaneously with Google Docs now.
Right.
That's
And so
true.
we're very diligent about that, I think.
But
you're right to say that no fault is an ever-changing, ever-growing, ever-developing type of really like a niche field of the law, which not many states follow no fault. And so we really have to be up to date and up to speed on all of it.
Because it changes frequently.
Yes.
And I think the volume of the no fault is where people can kind of get glossed over eyes, and they don't pay attention to detail anymore. But like you said, an eye for detail on each individual case is where it really can make or break the actual claim.
Mm-hmm.
Absolutely.
Absolutely.
Because we need to prove notice most of the times, whether it's mailing out the denial or mailing out scheduling letters or any of that stuff. We need to prove that the person received it. And in order to create a presumption of mailing, we need to have a tight mailing process. One digit off of a zip code, like you said, will break our case because our adversary will argue that it may not have gotten to them.
That's right.
Right. Well, that's what attorneys are meant to do, right? And so I think also our relationships with the examiners are tremendously important, especially at the claims process and that stage of the litigation. Again, for each individual case, we've developed such great relationships with the examiners that oftentimes they'll call us and ask, if they're within the time frame that they need to be, or how they should process a certain document or a certain claim that comes in. And I think that's really important, is to, if when in doubt, call us and ask, so that we can verify and ensure that the claims are processed the right way.
It's important on the claims end. I was asked by a vice president of an insurance company, where's the danger lie? How do we get hurt on these cases? And the answer was within the insurance company itself. What we do as insurance defense attorneys, there's no magic wand. If we get good material to work with, we're going to have success. So we like to break it down for each individual type of defense that there may be on the no fault litigation, the documents that we need. And there's a bunch of several specialized areas of defense. The denial based upon a no-show EUO needs to be perfect the whole way through. On our end, as defense counsel, what we like to see first goes into our summary judgment motion, pleadings, always first. The summons, complaint, and the answer. We want an adjuster or a litigation examiner's affidavit attesting to the processing of the claim and the denials and the mailing of those. Proof of mailing of the EUO scheduling letters. That needs to be perfect. The letters need to go in as an exhibit. We, in our office, use affidavits of service for the mailing of our EUO letters, and we also have an affidavit from the person who actually did it. Our process, we have found to be easiest, is the same person who drafts the letter, prints the letter, puts the letter in the envelope, stamps the envelope, takes it to the post office, writes an affidavit of service. It's seamless. We have found that instead of just sending it to a mailroom and describing the practices, if we're able to have that one dedicated person, which is often me, do the whole thing, then it's easier for us at the end of the day. We need timely denials, generally speaking, and did I miss any critical?
No, and in fact, I love that we have such a tight affidavit because it doesn't allow the plaintiff to poke holes in our case, and it's solid when it comes to establishing the notice.
And the addresses, us working with SIU on these matters, the addresses and the contact information for the claimants is also critical. If that's off or if that's wrong, you have to just give that little bit to a civil court judge, and they're going to want to not grant us summary judgment on this
Absolutely.
case.
Right, and oftentimes there's a lot of hands that are handling one particular claim. The more hands that get on it, if we're not careful about attesting to personal knowledge of certain things that each individual handled, the claim gets very messy, the litigation gets very messy, and it's very easy to poke holes in a defense of a claim.
Well, that's why consistency is key. That's why there's a practice and procedure that's in place both at our firm and with our clients. And it's consistent, it doesn't change. And
That's right.
Yep.
And then another thing that we do, we also have to, at the end of the day, we have to prove that the person didn't show up. And our technique for that is whoever the appearing attorney is, they put a statement on the record. That statement on the record gets sworn to most of the time by the court reporter. And when we draft a motion for summary judgment, our appearing attorney on the EUO will be the affirmation that we put forth in the motion. So this way the attorney can testify that I was there that day, I reviewed this transcript, it's accurate, person didn't show. So it's all done in one place.
Right, and usually that can be an appearing attorney at the motion stage. So,
absolutely,
just anticipating what plaintiff's arguments are going to be, oftentimes they will just, as a general, boilerplate argument, make that argument and say, well, how do we know, right? And so at that point, it's very convenient, and obviously we're doing it intentionally, but that attorney typically appears at our motions to tell the judge right then and there that they were the ones, that can personally attest to it. So, that's helped us a bunch.
the no-show IME denial. When we defend a no-show IME, the items we need, of course, again, pleadings, always first. We require, similar to an EUO, the documentation of proof of where this person resides and that we have a good address, that the scheduling letters went out in a timely fashion, the attestation that the letters were actually mailed, the denials, and usually we put in a general denial if it's available. And accuracy, it doesn't just need to be accurate, it needs to be perfect. We need to be perfect on the defense, and there's really no room for error. The law is very strict and the regulations are strict on what's required by the defense and by the carriers, and it's perfection.
Let's not forget that doctor affirmation. We also...
Well, like we said the no-show. We have to be able to establish that the person didn't show up, and it went as far in the affidavits from the doctors. The doctor couldn't just say, I had an appointment at this time and the person didn't show. No, it had gotten developed through plaintiffs creatively arguing, very intelligently, I can add, defects in that type of affidavit where the doctor has to say, on such and such a day, I was in my office. I was standing in my office at 12 o'clock. I was there from 12 o'clock to 1 o'clock. Nobody else walked in the door. I checked in the waiting room. Nobody was there. They really have to go jump through a few hoops to prove that the person wasn't there. Because if there's any doubt that this person didn't get a letter or may have showed up or there was confusion, our claim's going to get denied.
And also just to note that doctors see tons of patients all day long.
Yeah.
And so plaintiffs sometimes argue that they didn't have an independent recollection that this particular person did not show up at this particular time on this particular day. So oftentimes our affidavits include the fact that they reviewed their records, that there's a procedure in place in their office, in their doctor's office, that include these types of records where a patient gets marked down in these records, and if the absence of that patient is there, then that also helps us prove our case.
Right, there's a hearsay rule. Not to get into too much of the rules of evidence at this particular time, but there is a hearsay rule, which hearsay is basically taking someone else's statement and trying to admit it as being fact or true. And if there's a scheduling letter, we need to establish what's called the business exception, meaning that if a document was kept in the regular course of that business, and it's in the regular course of business that document is maintained, then it might be able to be used as a business record of that organization. A lot of times these records and the mailing of things especially, and the intake procedures that are in place are established business records and procedures that are very important.
Absolutely.
And the last thing that I can think of on this is for an IME no-show defense, what we've seen happening lately for insurance carrier purposes and for the adjusters who might be watching this video is that case law has mandated that once the claim is received, an IME has to be scheduled within 30 days of receipt of that claim.
Same with the EOs.
Right, and so a lot of the time we know for a fact that this person didn't show up, and we can have everybody's affidavit and affirmation stating as much. But if we did not schedule that IME or EUO in a timely fashion, we lose on a technicality, and it's frustrating for the insurance carrier, understandably so. But we need to make sure that we're adhering to those timelines that are set forth by the court in case law.
Yeah. I do think that they're wrong, because there are two different types of verification. There's the verification of a claim, a bill comes in and you want verification on that. But then there is that power that gives us in the regulations that these EUOs and IMEs can be scheduled as often as reasonably required. So it shouldn't have to be only 30 days after a claim. But there is a case law, and everyone hangs their hat on, that says that if it's a verification request, it must be scheduled pursuant to the verification laws. Which is another topic.
We've tried to overturn that many a times.
And we will keep trying.
One of the defenses the insurance carrier has is that they never received the bills. And that's a legitimate defense. If we didn't get the bills, how can we pay or deny them? An interesting thing in non-receipt, for us to defend that, there has to have been, a business procedure or practice for the insurance company to check to see if they received the bills. If they didn't and we established that procedure, we make a summary judgment motion with the examiner or litigation adjuster's affidavit. In defense, just the other day, there was a cross motion made, and the plaintiff said they mailed the bills. There was an affidavit of mailing identifying that they mailed the bills. But the affidavit referred to post office stamped receipts to show that the bills were mailed. And they did not include those stamped receipts in their cross motion. So in opposition to their cross motion, our position was that there was just an affidavit saying that they mailed it. They referred to these documents, but they didn't have them in as an exhibit. It doesn't get more complicated than that, really, with that. It's either we established that we didn't get it, plaintiff has to show that they did mail it.
Yeah, pretty much. And once they do, they prove a presumption of mailing, and then we can't refute that. That's
very
the end of
difficult.
it.
IMEs and peer reviews. We speak about them together because they're both medical necessity defenses. For a claim to be made, of course, we know that it needs to be medically necessary. Our experts review the medical records or examine the patient and determine that either they're okay and they can go on with their lives, or that the treatment that they received was not medically necessary. Is it important to have the same specialty review the documents and perform the peer review?
It's not only important, but it's necessary for us to submit the affirmation or affidavit of a doctor or chiropractor or licensed acupuncturist to determine that the services that they are reviewing are not medically necessary, that has to be within their specialty. It's improper to have a chiropractor review, for example, an orthopedic surgeon's bill. Oftentimes we'll see specialists in one practice area denying claims and alleging that the services were not medically necessary for specialties that are outside of their realm of expertise. That in and of itself is improper, and our defense will not be upheld at that point.
Yeah, it's definitely not a strong case.
What about one of your favorites we termed the piggyback peer?
Oh my God, the piggyback peer. That's when a doctor determines, for instance, that a type of medical test was not medically necessary. And the language we like to see in the peer review is not only was this test not necessary today, but any future tests on this patient would also be not medically necessary, because if the first time wasn't necessary, how's it going to change, right? And we call that the piggyback peer.
Right. But
We used to lose a lot on it, and then all of a sudden there was a turn. We started to prevail and do really good with that defense.
Yeah, the reason it was a struggle for us with that type of a peer review to defend was because the arbitrators and the judges would say, well, it wasn't necessary for this person to have this particular acupuncture treatment on this day, but to say forever, say all moving forward without an IME, only on a peer review, they weren't buying it. They wanted each individual date of service down the road to be re-reviewed again by the peer review doctor, and then issues specifically as to that bill.
And something that's important to keep in mind is when denying services, a good rule of thumb is the IME, the independent medical examination, the doctor examining the patient can say that future services are not needed. But when you're submitting a peer review as a defense of your medical necessity claim, that is reviewing services for something that already happened in the past. A peer reviews things that already occurred, and an IME should be cutting off services in the future.
The fee schedule defense. Oftentimes, medical providers will submit bills on the fee schedule and they're just wrong. They get sent out by the insurance carrier to reevaluate and have the proper fee schedule. By the time they come to us for our defense, the fee schedule has been determined and a denial has been issued. For us to defend those fee schedule cases, our best proof is a certified coder. A certified coder is going to trump everyone else because a certified coder is considered a professional. And having the certified coder set forth in detail in their affidavit how they came to their conclusion on the fee schedule is critical. And in a nutshell, the fee schedule is determined in New York for no fault by the workers' compensation fee schedule. And briefly, each particular type of service has a code associated with it. It has a relative value, which they call units of how much that is worth, and then that gets multiplied by a regional factor. In New York, we're in Region 4, depending on where you are. And those numbers combined, multiplied together, will give you the amount that it should be. But there are it's a complex area because there's a lot of ground rules which they refer to. For argument's sake, certain procedures that are performed individually can be charged at one rate, but if they're performed on the same day, one after the other, they get reduced rates. Just an example, there are a lot of intricacies in the workers' compensation fee schedule, so having a certified coder on board is fantastic, and
It helps us win.
yeah, it wins on the fee schedule.
And our defense is ironclad when we have one, but it's not enough to say, I'm just familiar with this third-party system of calculating, or I'm familiar with this certain database. You have to be a certified professional coder in order for us to maintain that defense.